And welcome to the first Nervitz Protection webinar. My name is Echan Rip, and I'm an associate here with Nervitz Protection. It's my pleasure to welcome you to Bill 148, a guide for employers. Before jumping into the substantive parts of our presentation, I'm going to turn the matter over to our articling student, Kellyanne Day, to walk you through the mechanics of the GoToWebinar platform in order to ensure that everyone has a seamless experience and is able to access and understand all of its features.
Hi everyone. So before we begin, I'm just going to point out a few of the features that we'll be using today. Firstly, if you want to adjust the size of the screen or the slides or the video portion, simply scroll over either part of the screen and arrows should appear in the bottom right corner. Clicking these arrows will allow you to shrink and enlarge the slides and webcam according to your preference. Secondly, somewhere on your screen there should be a control panel. It may be minimized, so you may need to expand the window by clicking the orange button. On the control panel, there's a tab entitled Audio. There you'll find a sound check option, which will allow you to adjust your sound settings so that they're optimal for you. Also on the control panel is a tab entitled Questions. At any point during the presentation, please feel free to type in a question and send it to us. Please note that these questions are only available to be viewed by us, and the other viewers will not be able to see what you've sent in. Once we reach the end of our presentation, we'll do our best to address as many of your questions as we can. Lastly, after today's presentation concludes, we'll be circulating our slideshow for future reference.
Thank you, Kelly. So this afternoon, we'll be discussing 6 of the more significant changes brought about by Bill 148. And you'll see them listed in the slide above here. Bill 148 has made changes to several pieces of legislation, including the Employment Standards Act. However, for our purposes today, we will be dealing exclusively with the changes made to the Employment Standards Act, which I may at times refer to as the ESA. As we go through each of these key changes, we will point out what, if any, the previous rule was, what the new rule is, to whom it applies, when the rule became or will become effective, and discuss practical concerns created by these changes. At the end of our presentation, before the question period, we will also discuss the enforcement mechanisms that have been put into place to encourage compliance with the altered new regime. Throughout this presentation, we will draw your attention to the practical implications that the changes will have on your businesses and the actual obligations that you have as employers to ensure that you are in compliance with the law. We note that this presentation is not meant to be a comprehensive review of each and every detail of the revisions to the legislation. Rather, it is a summary of highlights that we believe are the most widely applicable and are the most impactful to businesses such as yours. So the first item we're going to deal with is changes to various employees' leaves. These leaves also, some of them are new, many of them existed previously, but they've been altered in significant ways. We'll discuss each of these in turn. It is important to note for all types of leave, employees remain entitled to their same job upon their return to work. It is also important to note that unless a minimum period of service is required by the legislation, probationary employees are entitled to these leaves as well. So we'll start off discussing personal emergency leave. And this is one that previously existed, but it was only available to employers who had 50 or more employees. Now it's available in any size of workplace, and it's also available to all employees, including those on probation. An employee is entitled to a cumulative maximum of 10 days of personal emergency leave per year. These days do not have to be taken consecutively, and it should be noted that the first 2 days of this leave, the first 2 of the 10 days, not the first 2 of some portion of them, but the initial first 2 days of this leave that are taken are paid. So you have to pay for those first 2 days. Another thing to note is that while it's called we refer to them as days, even a part day under this form of leave is counted as an entire day. So if an employee has to take off half a day under personal emergency leave or a few hours, it all counts as 1 day. So employers, when faced with a request for personal emergency leave, are not entitled to ask the employees for a doctor's note, as not every personal emergency leave is medical. However, the employer can request evidence that is reasonable in the circumstances. What does that mean? Well, there's no indication in the legislation as to what this actually means, which puts employers in a tight spot. Our advice would be to tread with caution and deal with each situation on a case-by-case basis. The best thing to do is, if you encounter a situation where an employee is asking for this type of leave and you're unsure as to whether they're entitled to it, seek some sort of evidence, or they're entitled to seek some sort of evidence. Please do not hesitate to call us so that we may provide you with case-specific advice as to what you are entitled to ask for under the circumstances. The next leave we'll be discussing is family medical leave. This one here came into effect on January 1st, 2018. It existed previously, but has been significantly enhanced in terms of time and coverage. Now, there's no minimum period of employment that employees are required to have to be entitled to this type of leave. And unlike personal emergency leave, in this case, the employer is able to ask for proof of why it is being taken. As you see from the slide, proof comes in the form of a medical certificate. There's no obligation on the employer to provide pay during any point of this leave. So this type of leave, it doesn't apply to the medical leave regarding medical leave for the actual employee. It's medical leave it's family medical leave. So basically, the employee here has to take care of some sort of close family member. And there used to be a narrower definition of what types of close family members counted for this type of leave. And the list was restricted only to parent, step-parent, foster parent, various sorts of children, so child, stepchild, foster child, or if the employee stays in a blended household, maybe they're one of their children, or the employee's spouse actually as well, and other prescribed family members. Now this definition has become far more extensive, and it includes, and you see it listed here in the slide as to the amount of people that includes grandparents, aunts and uncles. But the last thing is, it says even a person who considers the employee to be like a family member. So that's very broad. But I mean, as long as it makes sense as to who the leave is being requested for, and I think the relationship should be set out in the medical certificate you'll be requesting from the employee. There's no problem with the request for this type of leave. Moving on to our next slide, domestic and sexual violence leave. Now, this is a new form of leave that came into force on January 1st, 2018. This one does come with a minimum service requirement of 13 consecutive weeks in order for an employee to take this kind of leave. And it is also a paid leave, but only for the first 5 days of leave. The total leave available here is 15 weeks, though there are actually two lengths available. There's a 10-day, there are 10 days available, and 15 weeks. I think the rationale behind that is, if you're, and you'll see from the next slide the various situations this applies to and the reasoning for it. If you're dealing with maybe an incident, you may need to access the days, but if you're dealing with a treatment, you may be needing to access the weeks. So this leave applies to situations involving the employee themselves or their children. And you'll see the reasons set out also in the next slide. Now here, the employer can require some form of proof for the reason the employee is making this kind of leave request. Part and parcel with that, the legislation sets out a duty of confidentiality for this type of leave that it puts on the employer. Now, even though the other sorts of leaves we've discussed and will be discussing don't have the same legislatively mandated duty of confidentiality, meaning that the Act doesn't tell the employer this is confidential, the information you get here is confidential. When the employee requests this leave and any information they give you as to why they're taking the leave is confidential. It's the best practice to maintain confidentiality in all of these situations. There is a lot of litigation dealing with improper release of personal information out there, and it doesn't usually end well for the party who improperly disclosed the personal information. While privacy issues could be their own presentation, we would just wish to emphasize that the employees who are in charge of scheduling leaves and have access to this personal information should be trained to understand the duty of confidentiality and the implications of a breach. And just looking at our second slide here, you see the purposes of the domestic and sexual violence leave. And you see a number of these things. You're seeking medical attention. That may be where you initially, at least, the employee's asking for one of those 10 days. But then you have other things where there might be a temporary relocation, some other sort of therapy or the like, where they would need to use those part or all of those 15 weeks. So the next kinds of leave are actually two distinct kinds of leave. There's child death leave and crime-related child disappearance leave. Now, previously, these two types of leave were combined in legislation, so now they're separate and distinct. The result meaning that a worker could take both types of these leaves in 1 year if both things were to happen. I could see them both having the same transaction rather than just being restricted. Obviously, the subject matter speaks for itself. One technical point to keep in mind with a request for these two types of leave is a 2-year maximum or 104-week leave maximum. And in both the cases, so in the case of the child death leave, the 104-week leave starts, or the entitlement starts from the day of the child's death. And with respect to the second part, the crime-related child disappearance leave, the 104-week entitlement starts from the date of the week the child disappears. So if it's taken later than those two starting points, there's less leave available. And this is also an unpaid leave. Now we move on to pregnancy leave. And this has a change as of January 1st, 2018 that relates to one specific circumstances. That being, as you'll see on the slide, for employees who aren't entitled to parental leave, this leave ends either on the later of 17 weeks after it commences or 12 weeks after the birth, stillbirth, or miscarriage. So what has changed is that second part. It used to be 6 weeks after birth, stillbirth, or miscarriage. Now it's 12 weeks. And employers are not required to pay employees who take pregnancy leave. And it should also be noted that an employee that has commenced pregnancy leave prior to the January 1st, 2018 change falls under the old legislation and does not get an increase in their entitlement if they were to fall into a situation where the 12 weeks or 6 weeks previously would apply. Next, we move into one with wide application that all of you probably have had to deal with, and that is parental leave. This has had the most significant change affected employers. Previously, employees were entitled to an additional 35 weeks of parental leave after the 17 weeks of pregnancy leave. Now the maximum is an additional 61 weeks after 17 weeks of pregnancy leave, or I believe 63 weeks if no pregnancy leave was taken. So the previous maximum of 1 year has been increased to 1.5 years. And these changes were brought about to match up with the ESA timelines, with the new EI timelines. As you may be aware, EI is being paid out for a longer period of time than it previously was, for 18 months. However, the amount being paid over the 18-month period to the employee is still the same amount as previously paid. It's just stretched out So the average EI check is less than it used to be under parental leave. So while the legislation does not require employers to pay employees on parental leave, this change is particularly impactful to employers who contractually agree to top up employees during their parental leave by bridging the gap between their regular wages and EI. Now, as I said, since an employee's length of entitlement to EI has been extended, these top-up policies are much more costly than before because you have lower payments than before stretched out over 1.5 amount of the time previously. So for employers who have a top-up policy and want to try to avoid this cost, the extra cost, I should say, it is important to note that such policies cannot be unilaterally changed. They can only be changed upon an agreement between the employee and the employer. They are rights granted by contract to the employee, and the only way to legally alter those rights is to negotiate something new. You need to offer something new to the employee, for example, a bonus, additional vacation, other incentives, a raise, any of those type of things, and the like. And the employer has to agree to make this change in order for it to be enforceable. And this is what the law calls fresh consideration, and it is necessary for a contract to be valid. And remember, policy changes like this cannot be forced on objecting employees, and employees can't be punished for wishing to adhere to their existing contract. Any unilateral changes to employment terms, such as top-up policy, may give rise to a claim for constructive dismissal. So the next type of leave we'll discuss is critical illness leave. Now, previously, this type of leave was called critically ill childcare leave. It has been changed to include other types of family members as defined in the Act. This type of leave does require medical evidence be provided to the employer in the form of a certificate. It also comes with a minimum consecutive service requirement and is unpaid. As you'll see from the slide, like family medical leave that we discussed before, this type of leave, as we say, used to just apply to a child. Now it's had its family member and just general definition of who it catches radically expanded. So you see here from the list of everyone it applies to: spouse, parents, various sorts of children, grandparents, sibling in-laws, step-sibling in-laws, and also the aforementioned and nebulously defined person who considers the employee to be like a family member. So very wide application, but the medical certificate, in addition to telling you about the family member's condition, will likely also point to the relationship between the employee and the person. Moving away from the leave, we'll discuss one of the bigger changes in the legislation, definitely the most substantive change. And this is where we encounter the independent contractor versus employee distinction. So the big change here is that the burden of proof for proving the nature of the relationship has shifted from the employee making a claim and demonstrating that they're actually employee, not an independent contractor, to the employer to disprove the claim by what they have characterized as independent contractors actually being an employee. Now, it's important to understand that a written contract between you and the employee is meaningless if the practical reality of the relationship between the employer and employee does not reflect what is written down. So what happens in practice is what's important, not necessarily the contract. The contract's one piece of the picture, but if what is actually going on in the relationship is something different, a court, tribunal, and other administrative body is only going to care about the actual mechanics of the relationship. And we'll see on the next slide, which it deals with all the factors that these decision makers look at in making the determination of the issue. What we like to say is, if it walks like a duck and talks like a duck, it is a duck. So you'll have, situations where maybe the employer wanted the person to be an independent contractor for some reason, usually to have to avoid certain obligations that belong to employees with independent contractors. And certain situations, somebody who would otherwise be an employee wants to be categorized as an independent contractor for certain tax benefits or other similar things. So this is one of those things that only becomes a problem when it is a problem. And that is most often when an employer is looking to end the relationship. When the employee who has been passed off as an independent contractor realizes that things are coming to an end and they won't have the security of notice pay or any other statutory protections offered to employees under the Employment Standards Act, they may decide to bring a claim to the Ministry of Labor or before a court to find that they were actually an employee and seek the entitlements they would have received if that were the case. Now, a worker may also ask for this issue to be decided during the currency of the employment relationship. For example, a dispute could arise where an employee being treated as an independent contractor all of a sudden seeks an entitlement under the ESA. Could be one of the leaves we were talking about, could be something else. But they could decide that they want to pursue one of those entitlements. And I think something to think of here is what we discussed very early on, which is if an employee goes on leave, their job has to be available for them when they come back. If you had an independent contractor, that wouldn't be the same thing. So as I discussed at the outset of this section, in either situation where you're facing a claim or a complaint, one of the biggest changes to this part of the law is the onus of proof. So the employer really has to do their best to show that the person was actually an independent contractor, not the employee. And that can be difficult given whatever the evidence is. So it's always best not to have the burden, but now the burden is on the employer. If a determination is made that the worker is actually an employee rather than an independent contractor, there are a few practical effects that you will need to be cognizant of. Firstly, the determination made by the court, tribunal, or employment standards officer will be retroactive. So this means that you will have to bring yourself up to date with tax, source deductions, and other entitlements that the true employees have, such as vacation pay, for instance. Secondly, in the context of a terminated employee, you will now have to pay the statutory notice and potentially common law pay in lieu of notice and severance that they are entitled to now that they have an employee status under the Act. Thirdly, you may be subject to an administrative fine depending on the facts of the particular case. Now, as we just look at the second slide here, you see a list of some of the factors, and this is by no means a definitive list, but these are a variety of the factors the courts, tribunals, and decision makers look at when deciding whether or not a person is an independent contractor or an employee. Basically, if a business calls most of the shots, the relationship is likely an employee-employer relationship. If the independent contractor has a lot of risk and has a high level of control over all sorts of the working relationship, they're an independent contractor. But this is not always an easy determination to make because of the ever-changing nature of working relationships, and many industries have their own unique nuances of how they treat their employees or independent contractors. And in some cases, a worker may have started out as a true independent contractor and then slowly morphed into an employee over time as the way in which they worked and they were directed to work changes. So this is a highly litigated area and one which will likely become more of an uphill battle since employers now bear the burden of proving the nature of the relationship. So it's always good to take a look at your workforce and look at the people that are working for you as independent contractors and take a good, long, hard look at what the true situation of the relationship is in order to determine if this is an area of some exposure for you possibly in the future if the relationship ends. And we'd always be, and this is something that you should definitely consult with us on if you have this if you want to do this kind of review. Next, we look at equal pay for equal work. which is basically meant to, and it comes into force on April 1st, 2018. And basically it's to protect and ameliorate the rights of people who are not full-time workers. So part-time workers, temporary and seasonal workers, those sorts of people that may be paid less for doing the exact same work that your regular employees, full-time employees do. So the rule here is employers must pay employees, regardless of their employment status, the same rate of pay for doing substantially the same type of work. Now, the term rate of pay is not defined in legislation, but presumably refers to wages only and not benefits. And this rule also applies to temporary help agencies. So when you get employees for temp agencies, this applies to them as well. And the third bullet on this slide is very important because it provides the employer with a justification for the pay differential. So what we'll deal with in a minute is how these sorts of complaints are made and how it works. But as the employer, to have a justifiable response for the differential in pay that's defensible, and that won't result in having to pay the employee more or any fines, the employer has to have a pay policy in place, be it a pay scale policy on seniority, merit, commission, or any other factor other than sex employment status that shows why people are paid what they are paid. So this should be in writing because otherwise it's very vague. And obviously we don't deal with unionized workplaces in the employment sphere. This is non-unionized. But if you think of, you have pay scales for unionized workers and it shows how they move up, you could do something similar in your workplace to show why various employees are paid what they are paid, be it a merit system, be it seniority, but it would have to be set out in writing in order for it to defend the system, defend the pay levels to the other employees that are not full-time employees. So as you can see from the slide, reducing the rates for your full-time employees will not save you from having to bring up the pay of the employees protected by this element of the legislation. So here's the complaint process. Basically, employees now have the ability to initiate a review of their wages. The Act is unclear as to what an employee must do to initiate this process, but presumably this review will involve the employee asking the employer to confirm whether or not they're being paid less than their counterparts. So once an employee has requested a review, the employer has two choices. They can either adjust the employee's pay to come into line with what they should be being paid, equal to the full-time worker, or they can decline and provide a written reason for doing so, which is what I discussed earlier, where you have a pay scale, an internal pay scale policy that's in writing that your entire workforce should be aware of. If you're faced with such a situation, we would recommend getting in touch so that we may assist you with your response. Because basically, if you decline to make the adjustment, the employment standards officers will become involved and there'll be an investigation. Employers are also prohibited from intimidating, dismissing, or otherwise penalizing an employee for disclosing their rate of pay to another employee for the purpose of assisting them with determining whether the employer is complying with the equal pay for equal work provision. So you can't engage in some sort of a gag order policy. Our advice here is to refrain from instructing your employees, obviously, that they cannot disclose their earnings to other employees, and this may result in running over the aforementioned reprisals sections of the ESA. While it may seem like a way to control costs, it may end up costing employers more money and various other penalties than it is worth. Now, employee scheduling, the changes for this don't come into force until January 1st of next year, which is actually good because this gives employers a lot of time to prepare for these changes and become more organized if they run a looser scheduling policy currently. Now you'll see up there, you see on the slide something about right to refuse. So Well, comment about that is this. With respect to the right to refuse rule, it's important to note that an employer can still ask an employee to come in for a shift or agree to be on call on less than 4 days notice. There's nothing in the legislation that prevents an employer from asking. However, if less than the minimum 4 days notice is provided, the employee has an absolute right to refuse, and they can't be penalized for this. So we would therefore recommend that scheduling policies are tightened up over the course of this coming year in anticipation of these changes, so you can easily adapt on January 1st, 2019, when the right to refuse comes in and the minimum hour shift time rules come in as well. So those don't become a problem. Because in a lot of, not every business, but any business where I think of retail, restaurant industry, anything like that, this could become a problem, both in terms of cost and lost productivity. Moving along towards the end, minimum vacation. This has changed a bit, but only for workers or employees, who have more than 5 years of employment. So previously, all employees were entitled to a minimum of 2 weeks vacation under the Employment Standards Act. Bill 148 has increased this minimum entitlement to 3 weeks for employees who have 5 years or more of service. So this doesn't mean that if the employer already provides a vacation entitlement that exceeds the ESA minimum, that would be the ESA minimum now of 3 weeks, that they have to increase it. Rather, employees are only required to comply with the statutory minimum. So if you only offer 2 weeks now to all your employees, you have to offer 3. If you're already offering 3 to all your 5-year and more employees, you don't need to change that, but probably next time there's a renegotiation of the employment contract, it will be an element of negotiation. So just a quick technical note here, or a couple of technical notes. The calculation of vacation time is based on the definition of a vacation entitlement year, which is defined as either being a recurring 12-month period that begins on the first day of the employee's employment, or an alternate vacation entitlement year, which means a recurring 12-month period that begins on a date chosen by an employer, other than the first day of the employee's employment. So this means that if a 5-year employee's vacation entitlement year ends on or after December 31st, 2017, the employer does not have to provide the employee with additional vacation days, meaning anybody whose year hasn't finished on December 31st, 2017, it's a 5-year employee, gets this extra week vacation because their year isn't finished. Also, as before, an employee who does not complete either the full vacation entitlement year does not qualify for vacation time under the ESA. However, employees earn vacation pay as they earn wages. So if an employee works even just 1 hour, he or she still is entitled to at least 4% of the hour's wages as vacation pay. Vacation pay for 5-year employees has increased from 6% from 4%. Employees with less than 5 years of service continue to be entitled to 4% vacation pay. Now the next slide, everybody knows about this one, minimum wage, so I'm not going to spend too much time on that. These changes have received a lot of coverage in the news. You're aware the minimum wage has increased to $14 on January 1st, and it's going up another $1 to $15 on January 1st, 2019. And after January 1st, 2019, every year after that, the minimum wage is going to increase by the rate of inflation on a yearly basis. Student minimum wage has also increased, and it exceeds the pre-January 1st, 2018 regular minimum wage. So if any employer was counting on hiring more students to keep the costs at prior levels, they won't be able to do so. Also, for those employers who employ bartenders or servers who regularly serve liquor, their minimum wage is still lower than the norm, but has also been raised to $12.20 per hour, and will go up to $13.05 an hour in 2019. The important thing to remember here is that there is no obligation on an employer to proportionally increase the wages of those employees who were previously making more than the previous minimum wage of $11.60 an hour, unless their contract states otherwise. Obviously, anybody who is making less than $14 an hour has to be brought up to $14 an hour but they don't need to be brought beyond that. And your employees who already make more than your employees who are already at $14 an hour, you can leave them at $14 an hour. There's no requirement that they get a raise automatically because the minimum wage has become what their previous wage that it far exceeded minimum wage is. So you don't need to do an adjustment for that. So it's simply a baseline requirement, and there's no requirement to adjust anybody who's already above that level. But you can expect pressure from employees for increases in their pay, because that's just the normal course of business. Just like to say a couple of words about enforcement. We've talked in various parts about a lack of compliance leading to penalties under the ESA. So I just want to set out, as you see in the slide here, some of the changes to the enforcement mechanisms included in the ESA as a result of Bill 148. So as I discussed earlier, reprisal or punishment of an employee seeking to enforce their rights under the ESA remains prohibited, but the government has added certain enforcement mechanisms in order to give the legislation more teeth. For example, the government has announced that it intends to begin hiring more employment standards officers, which signals its commitment to ensure that employers are adhering to the newly implemented rules. They'll have more officers on the streets, so to speak, to ensure that compliance is going on across the board. Notably, the legislation now provides for the registrations of liens in situations where an employer is ordered to pay money to the Ministry of Labor or to the employee directly as a result of the contravention of this legislation. These liens can be registered against real or personal property, so just like a judgment in court that you may be familiar with. And they entitle the director to most of the rights and remedies under the Personal Property Securities Act, such as seizure of physical property and entitlement to proceeds from the sale. So acts very much like any other judgment, like enforceability is the same. So trying to avoid paying these fines or paying the employees what they're awarded can have an effect beyond just your business. It can have effect on the business's property and doing business as you would if you had a judgment against you. So we'll wrap up with just some issues to consider. So you see three key ones. Get my slides over. Many of the changes we have discussed today are fairly nuanced in nature and may lead to litigation if the situations are not handled properly. Here we have listed the three areas where we think employers should be particularly careful. Firstly, we would encourage you to seek legal advice before changes to any terms of employment contracts are made, or just the terms of employment in general if you operate without a written contract. As discussed, employee contracts cannot be unilaterally changed by the employer, and doing so may expose the employer to a claim for constructive dismissal. Receiving legal advice prior to renegotiating contracts with your employees will ensure that the changes made are enforceable and do not run afoul of the legislation or the common law. Secondly, since there are no legislative definitions of some of the terms included in the new legislation, we won't really know what these terms mean until a few cases get decided by the courts or tribunals or employment standards. Until then, we would encourage you to err on the side of caution and contact us to receive specific advice regarding the particular circumstances of the employee or situation in question involving the employee. Thirdly, if you are seeking to terminate an employee and are unsure as to whether they are a true independent contractor or an employee, we would encourage you to get in touch with us so that we can provide you with advice as how a court or tribunal or the employment standards will likely review the relationship. Receiving such advice is even more important now that the onus of the proof lies with the employer. Just because an employer pays a worker's company instead of them personally, it does not mean that the worker is not an employee. At this time, we're going to take a look at some of the questions you've sent in during the webinar and do our best to answer as many as we can. So Kelly's been looking at monitoring the questions during the webinar here, so maybe we can run through some of them.
All right, so we've got a question here about employee leaves. The question is, are employers permitted to ask for a reason for the employee taking leaves? And do employees have the right not to provide a reason? So the answer to this question is that it largely depends on the type of leave that's taken. For example,
yeah, as we discussed earlier, the personal emergency leave, you couldn't ask for medical evidence, but you could ask for reasonable evidence of why it's being taken. And most of them do have that reasonable evidence. So you can ask for a reason, but it has to be reasonable evidence. And that doesn't necessarily mean that it has to be very detailed. It could be vague. But I mean, I think the issue here is, you may have a different concern where you're dealing with somebody with a higher level of absenteeism, and then where you're dealing with an employee that's not away a lot. So I think it's best when you get the request for leave, probably if there's a concern of whether you're tentative about granting it or how you're going to deal with it, to contact us to review the employee's particular situation so that we can evaluate what you should and shouldn't be asking for in the particular situation.
Alrighty. The next question we have also relates to personal emergency leave. And the question is, can staff request not to use their paid personal emergency leave and save these paid days to a later day in the year? Or does it have to be the first two instances of personal emergency leave that are paid? So certainly an employee can request that this would happen. However, the legislation mandates that the first 2 days are the paid days. So
the problem could arise in this sort of situation if they make that request, you agree to it, and then their employment's terminated at some point during the year. They weren't paid for that, and that becomes part of a complaint or a lawsuit, and basically you haven't complied with the legislation, sorry. So that wouldn't be, my recommendation would not be to, I wouldn't see why they'd want to do that necessarily. And you want to stay, you don't want to run afoul of the legislation. So I'd be very tentative to agree to something like that.
Moving on to a question about the equal pay for equal work provisions. The question is, if employees are allowed to tell each other how much they get paid, are employers allowed to disclose all employee salaries? The answer to this question...
That's a privacy issue, and if I'm an employer, I would never do that. Unless you had consent from all your employees, but I would never do that, because that is a significant breach of privacy. I would see that being viewed by a court or a tribunal as being a serious breach of privacy.
Let's see, and then...
However, just to go back to that for a second, what I spoke about, we were dealing with equal pay for equal work. I was talking about having a pay scale policy in place. If you had some sort of pay scale policy in place, it may not disclose individual salaries, but it would show salary levels. So I suppose somebody could figure out from that if they knew how long somebody had been employed, how much they were earning. But I wouldn't assign names to any of that, because you wouldn't want to do that, basically.
A couple have actually come in just as we were discussing these last few answers here. So the next one is, can I request staff to submit attestation forms when requesting leave, especially paid leave, so that they can declare that they have provided truthful information? If not, how else can I ensure that staff are not lying?
The legislation does not allow you to do that.
The question really is whether or not that would be reasonable in the circumstances. So like Etan was saying before, if you perhaps have an employee who has an employee file this thick because of all their absenteeism issues, there might be more inquiries that could be made of that type of employee.
But I still think getting something, a sworn attestation, I can't see a court or any decision maker looking too kindly on that, because I think that sort of document, in my view, is if I'm receiving it as the employee, I'm probably going to want to seek legal advice before I sign that. So I don't think you do that. I mean, you have to do some sort of workplace investigation. If you're concerned that it's not legitimate, there would have to be some sort of investigation done. But I don't see that being allowed by a tribunal court. I just don't see that sort of a document working in the employer's favor for a variety of reasons. Not only that, but just how it would work logistically. And I don't think if an employee were to get legal advice, I wouldn't see them being too likely to sign it, because, I mean, there would have to be some of the employment contract forcing them to sign it as well. So I don't think you just throw that on them, and I don't think it would work on any level.
And also, with some of the types of leave, the only requirement in the legislation is the medical certificate. So
I don't think some reasonable evidence is a signed attestation. I don't think that's what the legislature intended by that at all.
Okay, the next question is regarding vacation pay. The question is, we pay 11%, including all stat holidays. Are we still okay with that percentage? So the percentages are 4% and 6%. So as long as you're in excess of the statutory minimum.
As long as you're in excess of the statutory minimum, you should be okay.
The next question is also related to leave. If employees are permitted to take various types of leave, does the employer continue to pay health benefits while the employees are away?
That's going to be, well, employee benefits are not legislatively required. However, if you pay them normally, they're supposed to be paid. Like, for instance, when you terminate an employee, they continue through the entire notice period. And if you were paying them when they're on leave, I think it's not an ESA recommendation, but if you were taking them off benefits during one of these leaves and there's a problem, you'd be liable. So they should, and this is something we could look into further for you and get back to you on. But I see liability if they were discontinued. But we'll look into that, and we have everybody's name here who's asked questions, so we can definitely flip you an email with an answer to that.
The next question is, has the period of notice in lieu of pay or pay in lieu of notice changed?
No, Section 57 of the ESA has not changed. The employment standards and minimums for notice pay, notice of termination, or pay in lieu of, those have not changed. They're still the same. But obviously, those are only minimums. And if you haven't contracted to the minimums, or you haven't contracted with the employers to some sort of set amounts, common law notice still applies.
And then the next and last question that I have here is, are the unused personal days, or do the unused personal days need to be cashed out at the end of the year?
So I'm not sure exactly what that refers to, but none of these leaves have any carryover. And if you're talking about cashing out, if you haven't used the leaves where there is pay for them, those don't carry over. They're not cashed out. They're only paid out if they actually occur. So it's not like where you have some contractual obligation with your employees where if you don't take X amount of vacation, you get paid out a certain amount at the end of the year, or your days carry over. There's no carryover, and there's no obligation to pay any of these amounts for things that don't happen. You're only dealing, vacation pay is the only thing you're paying out, nothing else, unless something actually is used, but there's no cash out on any of these. I think it was a personal emergency leave. And a couple of the other leaves, where there's like 2 days, first 2 days are paid, 5 days are paid. That's only paid if it actually happens. It doesn't sit in abeyance somewhere and gets paid at the end of the year if you don't take it. So the answer to that is no.
So that looks like the end of all the questions that we received. We can take a look for another few seconds here if any are coming through. So if you had something that you were thinking of, you can feel free to send it along. We do have a couple more minutes here.
And if you think of something later, you can send us an email and we'll answer it that way.
Or give us a call.
So we'd like to thank you all for attending today. And we'll just be on here for a couple more seconds, I guess. Yeah. And if we don't get any questions, we'll bid you a good afternoon. And we look forward to helping you and assisting you in the future with any of your employment law needs.
All right, we just got another question here.
Questions.
Can you briefly discuss the change to the calculation method for statutory holiday pay? So if we go, I can flip this slide back on so everyone can take a look.
That wasn't stat holiday, that was minimum vacation pay.
Minimum vacation pay, statutory holiday pay. Okay. So I don't think we have the percentages up on the screen, but essentially.
But he's asking, I think the question here is about stat holiday pay.
That statutory holiday pay.
Statutory holiday pay hasn't changed. So we can definitely get back to you on that. That's not covered in these changes, but that's definitely something we could get back to you on. Unless your question's about minimum vacation pay changes.
Okay, stat calculation. So essentially, the statutory holiday calculation has to do with the number of days worked in a pay period. It would depend, I suppose, on the hours worked by your employee. And if you're having, particular concern about a particular employee, we'd be happy to review their hours worked and compare it against the legislation to ensure that the correct calculation is being made there.
I think that's all the questions we're getting. So thank you very much for attending once again, and we'll talk to you in the future.
Thanks.